So good evening, ladies and gentlemen. Hello, hello, hello. Thank you very much for joining us. We are excited to be hosting you tonight. And we are looking forward to learning. We are looking forward to engaging. We are looking forward to learning through your experiences as well. And I believe that this is going to be an eye-opener and it will shed light or clarify a few of the challenges you've been facing in your day-to-day life. So, right. My name is Grace Nzula. I'm an HR consultant with Atara Solutions. Atara Solutions is a HR consulting and training company. We offer 4 services. We have HR manager outsourced. We have HR consultancy, where it involves your HR audits, your review of policies and updating, also developing new policies if you don't have any. And then we also offer training, learning and development. And there we have training for your organizations. We also have personal development engagements. And then we also offer, and that is where team buildings come. So if you have team building needs for your organization, please reach out to us. We offer those. And also your trainings, it's the end of the year, so book us for all your training needs. We are a one-stop shop for training. And then we also do recruitment and selection. So you don't have to go through all the entire process of recruitment. You can reach out to us and we'll be able to support you on that. So you are tuned in to Get It Right with Atara Solutions, which is a webinar series that seeks to demystify issues in employment and entrepreneurship. We do this every Tuesday from 8 p.m. where we get to learn, we get to share, we get to technically demystify issues that affect employers and employees. So tonight we are dealing with the legal intrigues of abscondment or desertion. And next week we will be looking at money market fund. How do you invest in money markets? We want to make sure that as you begin 2025, you will be understanding where to take your money as we discuss how to budget again at the beginning of the year. We normally start with the financial segment. So, and hopefully next year we are still going to be doing the same. So with me is my co-host, Mr. Richard, and of course, Catherine Sidandi. Before I allow Richard to say hello, I will say thank you to Catherine Sidandi. Catherine Sidandi is our sign language interpreter. And for those of us who are in the IHRM conference, we learned how to say, I am HR. So it was really, really interesting to learn how to do sign language as well. So thank you very much, Catherine Sidandi. We appreciate you. And we are really honored that you are willing to do this. Please, guys, if you have an event, you have a training, please engage Catherine Sidandi because you need to also be inclusive. Let's reach out to more people. Let's be able to impact more lives and not just the people who are, or rather, including the people who are differently abled. So at this point, I will allow Richard to quickly introduce himself.
Thank you very much, Grace Nzula, moderator of choice. I am always very delighted to come and learn here to gain insights and perspectives so that we can elevate and propel our careers and businesses. It's always a delightful moment to have guests come and speak. And tonight we have one of the best in terms of legal matters. Ladies and gentlemen, my name is Richard J. Magoma. I am a trainer. I train in so many areas, especially public speaking and interview coaching. In case you want those services, you can reach out. Over to you, Grace, as we wait to get into the discussion of how to handle abscondment.
Thank you for that intro, and allow me to also just give a shout out to our partners. It would be unfair to have this session without remembering them. So we have Nile Front Cottages. Nile Front is a hotel located in Jinja, Uganda. Now, if you want to visit Jinja, it's from Kenya. It's 2 hours away from Busia border, and it's about an hour and a half away from Kampala. So those in Kenya, those who in Kampala, your Jinja is right in the middle of us. and it's one of the most beautiful places you can be at. They have quite a number of activities to be done. Nilefront Cottages actually is one of the most beautiful places. It's near where the Lake Victoria meets River Nile. It's also one of the few cottages where you can actually view the sunset and sunrise from specific points of the cottages, and the design is amazing. You just go in, enjoy your stay. It's very comfortable beds, and then they also run a restaurant in the middle of town called Skia. Skia is a restaurant that the people who do serve are those with hearing impairment. So it's such a beautiful to go there, and you get to learn actually sign language. Their menu has sign language as well, so you get to order using sign language, and then they will be able to serve you. And they have such beautiful customer service. And one of the things that when I was talking to the guy who owns the place, I was like, how do you actually train them? And we got an interesting whatever, because training the people who speak in sign language, it requires a lot of dedication and quite a lot of patience. And it was quite interesting and intriguing for me as a trainer, because it's really amazing what they do. And then we have Elsa Mea. Elsa Mea is a hotel located in Naivasha. Please visit Elsa Mea. Kindly go and learn about Elsa. Go and enjoy the serenity. Go and just chill. Go and have a cup of tea. Go and spend the night. Take your conferences, your end of year parties. Go there for New Year's. I mean, it's just an amazing place to be at. We have the conference facilities, which is not too big, by the way. So you can actually book the entire place for your organization, and then you can just go and enjoy. If you want to take a holiday, you can go their rooms. There are some of the rooms that are actually lake facing. From your bed, you can actually view the lake. So it's such a beautiful place. We have K Square HR Services. K Square HR Services are our partners located in Rwanda, Kigali. If you're looking for partnerships, HR services, training and development for your teams in Kigali, Rwanda, then K-Square HR services will be able to do that for you. We have AAR Insurance for all your insurance needs. You can take on your WIBA, you can take on your medical schemes. They have quite a number of variety of offerings that they have. Then we have Steadfast Quality Solutions. Steadfast Quality Solutions is our partner in Kampala, Uganda. Now, this Steadfast is a HR consulting and public relations company. If you're looking for somebody to do your board trainings, board evaluations, then Steadfast Quality Solutions will be able to conduct that for you. They are also experts in coaching. My good friend Herbert Zaki, who heads the organization, is a Gallup certified strength coach, and he has coached over 500 executives. So you're in good hands by taking on coaching by Herbert Zaker. We have Profiles International. Profiles International are the only people in Africa who are certified to offer Gino's emotional intelligence certification course. So it is important that you actually take on that to become an emotional intelligence coach. And then you can also, if you are looking for people to do your psychometric assessments or to teach you how to do psychometric assessments, then Profiles International offer you that service. We have Labor Planet. Labor Planet are manpower outsourcing company. We have Kapla Mintito for all your coastal snacks. We have Vanessa Training Institute. They offer training in carpentry. They have a next intake coming up in January. So if you know somebody, actually wait. On Panessa Training Institute, there's an offer, or is it an offer? KCB Foundation is sponsoring girls to start. The interviews are happening on the 13th. Wednesday 13th, that's when the interviews will be taking place. Please send any girl that you know is interested in studying or becoming a woodworker, and then they can get a scholarship, fully paid scholarship. They only probably need to do bus fare and accommodation. So please take advantage of that offer. And then we have Wicklin. Wicklin is a carpet cleaning and office cleaning company. Please don't stay in a dirty home. Don't stay with a dirty carpet. Don't stay with dirty sofas. Wicklin services will be able to do that for you. We have Hotel Sapphire. Hotel Sapphire is located in Mombasa. If you're in Mombasa, please go to Hotel Sapphire for their Friday band. They have such an amazing band playing there on every Friday. And then we have Port Sacco. Port Sacco, if you're looking for a Sacco, then you need to sign up with Port Sacco. So for your savings and your loans, they have amazing, amazing packages for you. And they're different for you who is an employee after you saved for a period of time. So you need to check out Port Sacco, and you can reach out to us for more details as well. And then we have the services offered by our partner, or rather my co-host, Mr. Richard. If you're looking to do interviews, then you need to take advantage of the offer given by Richard Magoma. We call him famously known as Coach Richie, or Mr. Positive flavors. He will give you tailored strategies for answering questions. He will teach you how to present yourself as a top tier candidate. He'll give you insights that are used by global leaders and employers. Then they will also teach you techniques for building strong connections and the best ways to showcase your strengths. That is what Richard will take you through. So please take advantage and get in touch with Richard. And then welcome all to the Africa Human Resource Summit happening in Kigali, Rwanda. From the 20th to 22nd of November, we will be going down to Kigali. Please join us. This conversation will be very rich in how we can come up with our own solutions, how we can become strategic players in our organizations, how AI is affecting us, or we will get to network and share the issues that are affecting HR in Africa. Please come, let us interact, let us network, and let us learn. You can see the number of speakers. It's just going to be very, very rich and very, very enlightening sessions down in Kigali, Rwanda. And of course, we have our dinner coming up. I don't know whether you've seen these flyers. Please join us for this dinner. I don't know whether you've signed up. Please sign up. This is happening next week on Friday on the 15th. It's going to be taking place at Westwood Hotel in Westlands. We are only charging 4,500 shillings. We are going to be having fun. We're going to be learning. We are going to be interacting. We are going to be eating as well. Dress code is a touch of African. Please don't stress if you don't have, you cannot put on a kitenge. You can always get a touch of African in earrings, in a purse, in all those things. For the men, you can always get the whatever pockets, and you can also just be in the theme. So we are excited and looking forward. Actually, you know, this month is our final month for Get It Right with the Tara Solutions 2024 series. We shall be back again in 2025, bigger and better. But this month, this dinner marks almost the end. I think the last session is 27th or something. Is it 27th or 25th? Something like that of this month. That's when we finish. So please come join us on 15th, Friday next week, at Westwood Hotel in Westlands, and we're going to have fun. We are going to learn. We have quite a powerful speakers. We have Coach Vuyanzi, who is a coach, and she's such a wonderful speaker. We have Victor Komu, who is a HR expert. We have a business person, and then we have a keynote address who will come and teach us about mindset and how we can change our mindset to actually be able to move or up level our businesses and careers. Because my God, we do need a change of mindset looking at our pay slips, and we need to be positive about it, and we need to also realize that our mindset is what stands between us and growth. And that's part of the discussions that we're going to be having. So please do not be left behind. Join us on that date as well. So at this point in time, I know I've taken a bit of time, but it is necessary that we also introduce our speakers, or rather our partners. But at this point in time, we have our speaker, who is Mr. Peter Kinyanjui. He's a legal practitioner. I don't think he needs a lot of introduction. I think most of us have interacted with Peter Kinyanjui. He's been a resource person for Atara Solutions for a while, and he's done quite a bit of work from the Employers Association. He has also trained for the Institute. He has done quite a lot. I don't think he needs more introduction than it is. So Peter Kinyanjui, I know I've taken a bit of time, but take it away.
Thank you, Grace, and good afternoon to everyone. I hope I'm clear.
Yes, Kinyanjui, we can hear you.
Yes, as usual, I'm honored to be part of this rich dialogue and to just share our insights on the topic that you have today, which is on absconding and how to close those files for people who desert employment. My name is Peter Kinyanjui, as introduced, practicing advocate of the High Court of Kenya, a member of the Human Resource Management, and also a certified data protection officer. And I do not know the guidance in terms of time. Grace, if you could guide.
We can stick to the plan. Also accept to be moved as a panelist.
Yes, I also note my administrative rights do not allow me to switch the video on, neither do they allow me to share the slides. So
no, you have. Kinyanjui, be on the lookout.
Yes.
There's a prompt coming to your screen.
Okay. Oh, yes, I've seen it.
Okay. I'm telling you, today technology did me a number, but we are here. Okay, now you're able to share your screen. Thank you. Saying we want to see your face. Have you seen that? Let me just say Kinyanjui is married as well. Yes, Kinyanjui, you can take it away. You're on mute, Kinyanjui.
Okay, then then in the next few, I will be taking you through this landmine, if I may so call it, because in our usual business, which takes us to audit employers, this is one area that has always come out outstanding, and we have always flagged it as a landmine that is just waiting for an ideal time to explode. And this is more or less for employees who just leave employment, not to show up again. You try reaching them out, you don't get them, you try sending people. And what do we do? Mostly as employers, you find that you just close the file, you stop the salary, you just mark it on top closed. And the question is how safe that kind of closing of that file is. And we have found situations where an employee later on shows up and now either claims that they were verbally dismissed, and therefore it becomes the word of the employer claiming that this person deserted and was not terminated, and the version of the employee who is simply saying that they were told verbally by one of their supervisor never to show up. And these are cases we are handling in court on a daily basis, and unfortunately, they always go against the employer, which we thought that it is very important that we try and come up with a quick solution based on the court processes that we will hopefully make us be able to close that gap in employment. Now, we have also encountered quite a number of cases where matters are lost before the court based on how or the definitions that we attach to the dismissal letter or to the letters of termination. And in this case, maybe you want to distinguish between absenteeism. If someone is just absent, have they deserted? And that is key because under what is projected there, it becomes only a desertion only if you can prove that this person has no intention of returning to work. And that is key, and I would wish we underline that you as an employer can demonstrate that your employee is not willing or has no intention to come to work. If you cannot establish that, then that employee is absent. An employee, for instance, who does not come to work, but maybe is incapacitated by way of illness, and perhaps even lying in some hospital bed unconscious, and who continues to be so maybe for a month or even two. Has that employee deserted? Absolutely no. This person, once they get better, most certainly they do have an intention of coming back and resuming work. So once again, before you use that word desertion and absconding, which in this, for the purpose of this discussion means the same. That is, desertion and absconding means the same. Before you use it, can you prove to the court of law, if challenged, that you knew that this person was not intending to come back to work? And as we go on, you'll find that there are very many ways you can prove that you knew or you are aware that this person was not coming back. For instance, you are aware that this person has actually secured an alternative job, and that information is an information you can verify. They have signed another employment contract, in which case that can be a basis for you to now say that this person obviously does not intend to come and continue working under their contract of employment by virtue of the fact that they have since taken another contract. So as we proceed, that is the question that we want to put and carry along this presentation, that if you have no information, let's just stick to abstaining as defined as a misconduct under Section 44 of the Employment Act. How long declare someone to have deserted? This is something that has always been on and off. This is something we have encountered over and over in terms of the policies, the internal policies of organization, in terms of how do you define or how have you specified a period upon which maybe you can take action on an employee on the basis of absenteeism. Now, my reading of Section 44 is that it does not attach the number of days. And from where I sit, even if someone is actually absent for a single day and they do not have lawful justification for being away from work, then they can be summarily dismissed on the basis of absenteeism, since the same is defined as a gross misconduct under Section 44. But then, for the purpose of this discussion, we'll be looking at how generally it can be, or what factors, what boxes you need to check before you can conclude that someone is or has deserted work. Now, I know for many policies you'll provide if someone is maybe absent consecutively for 5 days. Of course, I've had an issue with that. When you say because it means if someone is absent for a day or two, then shows up for that on the third day or fourth day, and they do not have a legal justification, the policy still will not allow you to take a stern disciplinary action, since your policy defines that you will only take disciplinary action on the basis of absenteeism if an employee has been away for 5 consecutive days. That I always flag as removing the prerogative of the employer to take disciplinary action on any employee who absents themselves without permission or lawful ground. But in this case, we are assuming that we do not know where this person is by virtue of them not sought permission from the immediate supervisors. They have not sent anyone to explain their whereabouts. They are not reachable on phone. You tried, all the means that you use in regular communication, and this person is not able to explain their whereabouts. This becomes the subject now of how do we now, first of all, become justified to declare this person as having deserted work or having absconded work. Now, generally, the law does not give a specific period after which you can assess that the employee does not intend to come to work. In fact, experience, the law scorns upon this employer who is deemed to be trigger happy, that you cannot wait. And we've always been asked in court, what is the hurry? We want you to demonstrate what efforts have you made to find out what your employee is stopping you from coming to work. Why are you so quick to like run and close or dismiss? Now, generally out there, including comparative jurisdictions, it is accepted that this period should not be less than 5 days. But then, like I said, it's not only a factor of the 5 days, it is a factor of the main reason or the main ground or evidence that you'll be able to offer to exonerate you as an employer for taking disciplinary action on the basis of desertion would be your ability to prove the effort made to establish that this person is not intending to come to work, or the evidence that you have where you can tell or you can swear evidence before court and say that I was aware at that point that in any event, I didn't have to wait for another 2 weeks or 3 weeks because I knew that this person had already secured a different employment, and this can be established through a statement or any evidence that you can give to ground your inference that this person has since deserted work. And the obligation to inform the employee or to inform the employee, of course, the employee has the obligation to inform. That is a statutory obligation. But here we are dealing with the negative. The employee has not discharged that statutory obligation. So they are just missing without a trace, without information, without anything. They are simply not at work. Yeah, and we've distinguished that if you actually know this person, maybe he's unwell or he has a family crisis or something like that, then that is not action. Because after I am done with my family crisis, I obviously intend to come back to work. So I am absent, and that can be dealt differently. And that is, since that is not the scope of this discussion, we will be looking at a situation here where you do not know, despite all your efforts, where the employee is. In which case, as we proceed with this discussion, it will be your duty to demonstrate what efforts you have made or put in place to try and trace that person. Or two, that you are aware that this person in any event is not coming back and therefore no need to sit and wait. Having said that, I would want to use my usual style to just drive this point home using a decided case or decided cases in the Employment and Labor Relations Court, as I've always consistently advised my colleagues in the HR profession, that the law is dynamic. If you go looking for these definitions under the Employment Act, you will not find it. If you go and look for a procedure to execute a separation in such a case, you will not find it. So the only and the best way is to go back to the judge, to the judges who are always faced with these kind of situations, and they have to make a determination. And once they give a determination, it complements the law and actually becomes law that can be cited. This is what we call the judge-made law. So for the case that I have put in there, the determination came in the year 2023. So it's a fairly recent case. And the brief facts of or what was the key areas that I have been able to pick from this judgment is is for just like similar to any other separations. You know that the employer has a duty to inform the affected employees of the grounds on which they intend to take disciplinary action. And while at it, the employee also has a right to be able, should be allowed to appear, make their own representations. They have a right to be represented by an employee of their choice. They have a right of appeal. I am sure at this moment and time we are very well versed with the requirement of Section 41. Now, here we will be looking at the practicality of making sure that we follow the procedural prescription under the Section 41 for this employee who is not there, or whether, since they have not come, we are allowed to bypass Section 41 and just proceed and do a dismissal, or just close the file and just stop the salary, and that is it. Will you have complied? And if in the event an employee sues you, are you able to defend the employment? Are you able to defend capital? So with this at the back of our mind, this is what the court will still want to do. This is still what the court will still want you to justify or to show that you either complied, and if you didn't, what was the difficulty? What was the difficulty in complying with the requirement of Section 41? Why were you not, as an employer, able to accord this employee right to representation? Why was it not possible to do minutes or to have this person appear? Again, the onus will be on you. Now, I have already touched on the difference here, so I will not belabor too much on the absenteeism versus desertion. Absenteeism, we very well clear, no, we can invoke Section 44, and you may take disciplinary action, which includes summary dismissal, where an employee cannot show where they have been, or they cannot show a lawful justification for their absence. Yeah, so, and this denotes where indeed an employee appears, and in this case, you're able to take minutes, you're able to have him represented, and the only reason is that he has not been able to give a justifiable ground upon which or why he did not come to work. That becomes absenteeism as we know it. But the judge of the case that have cited is very clear that mere absenteeism from work does not in itself automatically constitute a desertion. Okay, and in this case, I always highlight on this because I lost a case that was very well established that could otherwise have or the employment would have been defended properly, but the only line that was picked by the judge. In fact, the judge was very clear that if this person had been dismissed on absenteeism, then that was very well grounded because there were no reasons that were given as justification for the absenteeism. But by the fact that the employer decided to use desertion, and the employer could not establish before the court that they are aware that this person was not willing to come back, and in the employee who has now gone to court and said that indeed I came back after 2 months or after 3 months, after I was done with my issues, and I was informed that I had since been terminated or dismissed. So in this case, the fact that the employer could not establish that they had grounds to know that the employee was not intending to come back to work made the termination unfair, and the company was ordered to pay compensation. So again, as we go, we'll keep repeating that you know that the employee had no intention to return to work. That is the one for the purpose of this discussion that we'll be describing as an absconder or as a deserter. And again, even where an employee has deserted, then it still becomes your job. It still becomes your duty, yeah, to still demonstrate compliance and all efforts to comply, and any challenges that you'd have encountered that made it not possible for you to comply with the procedural requirement under Section 41, which I have since alluded to and do not want to belabor a lot on it. It is not enough, and again, this is from the wisdom of the judge presiding over the case that I have presented, that it is not enough for the employer to contend. It is not enough for the employer to contend that the employee has basically terminated his contract through desertion. The judge says that if the employer cannot demonstrate that he accorded the employee a chance to rebut the accusation of desertion against him. So in this case here, the good judge is saying that you need, as an employer, to demonstrate that you accorded the employee a chance to rebut the accusation of desertion against him. So here again, we have gone a step higher. You have seen, or maybe you have got reasons to know that this person does not intend to come to work. And let me use a basic example. This was your driver, and you are aware that he has been seen driving a vehicle belonging to another company. And this can be established because you'll have statements from fellow colleagues and so on who will now have given you information that we know this guy is actually taken another job and is not intending to come to work. So I want to pose that you have that information. Then, does this person still have a right to be heard? The answer is yes. That even if they are aware, they are not. Even if you are aware that they are not intending to come to work, they still have a right to defend themselves or to rebut that accusation. So how do we offer them immunity? Yeah, here is where we always emphasize and underscore that now it becomes an issue of evidence. It becomes an issue of evidence. And on this, I have always gone back whenever we do our audit to whether you have contacts of your employee. Employment Act denotes must have their address, that is statutory information you must have about an employee. But over that, noting now we have more into other forms of communication, including their telephone contact. That would have been given to you as an employer in biodata, or they would have volunteered not only their contacts, but maybe of alternative persons that may be contacted if at all they are not reachable, or in case of an emergency. So the first thing is, do you have those information? Can you demonstrate that you have been communicating with this person using these means? If you can, it starts making work easy, because now to demonstrate that you have given them a chance to defend themselves denotes that you must send a letter inviting them, informing them of the offense committed, and also informing them of the consequences, and therefore telling them that if at all they do not come and exonerate themselves, then based on the evidence that you have as an employer, you proceed and take necessary action and dismiss or terminate them as appropriate. So here again, the court requires you to demonstrate that opportunity was availed. If that opportunity was not availed, then this termination or dismissal is unfair, and you may find yourself having to pay this person despite you having knowledge that they are not intending at taking active employment. In the wording again of the judiciary, you as an employer, you must take steps to close the contract of service of this employee who has deserted in line with the procedures stipulated under the law. Now, if I ask, and I know this will apply to many of us, the practitioners, and the delegates in this presentation, you will find that if you go and audit your files, and this is something I dare you to go and do deliberately, noting that the Employment Act allows an employee up to 3 years to present a petition against the company for unfair termination. If you go and do an audit running 3 years back, how many files will you find that have not been closed? And especially for these deserters, and I know with the turnovers and all this kind of stuff, you'll find that these are so many. If you ask a typical HR, they will give you details of people who have, they just leave. And what does the HR do? You just close the file, stop the salary, and that is it. Did you pay terminal benefits? No. Is there a dismissal letter? No. Was it communicated to anyone? No. Is there a certificate of service? No. All those are time bombs that could erupt when it is appropriate. And like I've said, within 3 years, employees could jump and they will come, and then you'll find yourself in a difficult situation where you cannot be able to justify your action legally. So deliberate, that file must be closed. And perhaps that's where we will need to go into, then how do you close that file? I will share these notes and you'll be able to read this citation on an in-depth, and of course, owing to the limited time we do have. But all these cases are very in hands of here and look a movie. The quote is very clear that the employer must demonstrate the efforts made in ensuring compliance. This is where you are not able to accord someone to invite them for a meeting, a disciplinary meeting, having issued a show cause, having told them of their right to come with the representatives, having a right to inform them of their right of appeal. If that was not possible because someone had deserted, then the onus lies on you to demonstrate what efforts did you apply to have this person informed that there is an intended disciplinary action against him or her, and that they ignored coming to or presenting themselves for that hearing. Okay, and the judges are very specific that even if I have deserted, it does not mean I have dismissed myself. Okay, even if I have deserted, it does not mean I have dismissed myself. I only dismiss myself if I have given you a resignation. In this case, you don't have a resignation from me and you've not heard from me. I am typically an employee until you terminate that contract. And that's what I told you is an active process. So the fact that he's gone does not mean he has dismissed himself. And that decision to end that contract of employment needs to come from the innocent party, the person or the party that is aggrieved. Here we have employer-employee. The employer in this case is aggrieved that an employee, my driver, has not come to work yesterday, the other day, the previous day. It's now 5 days. This person made touch, has not called, has not sent a colleague, nothing. Yeah, and either is completely unreachable, or we are aware that this guy does not intend to come because he has left work, and we have been seeing him running his border business out there, or he started his other business out there. We are aware. You, as an employer, you are the aggrieved party. You are the innocent party because you have not breached your obligation under the contract. So what should you do? Someone is not at work. What does the law give you or mandates you to do? Take disciplinary action and dismiss by virtue of Section 44 for absenteeism without lawful ground. Did you do that? The answer is no, and therefore you cannot be allowed by the court to just say that he didn't come, he absented, he absconded, and therefore that is like he decided to terminate the contract himself. And again, I'm repeating this. An employee cannot terminate the contract. If he wants to, he will need to do a resignation. The discretion to terminate a contract on the basis of discipline, performance, or physical incapacity under Section 41 is on the employer. And the section prescribes how that separation or termination must be executed. So again, this is the underscoring, show how many or what kind of attempts have you made to ensure that this person has been offered an opportunity to be had. Like I said, I will share these presentations. What I will just need to do in terms of closing for purposes of the participants here is maybe show you put the lens of the court to be able to guide you on how you need to develop an SOP. I know we've spoken with Grace, and we are likely to have a more elaborate kind of a training or a session that would be longer so that we're able to ensure that we back everyone with an airtight kind of a policy or an SOP to ensure that you close all this. But for now, what I will want to quickly highlight is then how do we now close this file properly? Now, first of all is that you must have evidence. Law is about evidence, and human resource is about implementing so many labor laws. Human resource is about knowing that whatever decision you're making could be a subject of the employment court tomorrow. And it will be your duty to keep document because that obligation is vested on the employer by the Employment Act. You will not expect an employee to be the one giving you these, being the one, or you're asking them to give you records. You are the one to give evidence. So the first thing is, once you're in court, and assuming I'm now the one representing your company, what I will need to defend your company is, first of all, give me the evidence that, and I'm taking this several scenarios. In this case, my assumption, or I'm more locked on this person who is unreachable and who did not respond to any attempts to have them come for hearing. So here, the first line that I'll be asking is, what did you do? What can you give me? Now, in this era of digital technology, I would want to see text messages that have been sent to this person. I want to see call logs from the number that usually communicates. And again here, the number that usually communicates, I know some companies will have a centralized line, which is usually very much encouraged. A centralized line that communicates to employees, as opposed to an employee who could be called from any other line and personal line from their supervisors, because then they can always say this is not work. But assuming in this case they know that this is the thing that communicates to them, then it will be good evidence if you're able to give me printouts of WhatsApp messages. As you know, the law has actually allowed this to be relied on. So I would want printouts where you are simply telling someone, we note you've not been coming to work and we have no information about on your whereabouts. We have tried reaching you on your phone number 0722 and it is not responded. That is evidence. We have tried reaching you out on your alternative contact, but unfortunately still not reachable. So that's good evidence, give me printouts, and please keep that evidence from the supervisor to this person and have it complemented with a statement and a bullet 4 from your supervisor. And in this case, it should be the supervisor through a written statement that should be giving you that statement that my employee XYZ did not show up on date 1 and did not show up on date 2. On the 3rd, I tried calling on this phone contact which he has applied to the company, and these are the call logs. They did not respond. I did a text. This is a copy of the text. They did not respond. I did a WhatsApp. They did not respond. I sent a colleague to them, and the colleague came back. Okay, the first statement is from the other one. You have sent your colleague. Can you find out? Go to their home. Find out whether you can lock your hands on the reason this person isn't coming to work. And once they come, they will tell you, yes, on this day, I was given a letter to deliver to this person. I went to a place, their nyumba or their house where I know it, and either I found that they have since vacated or I was told this, and in some cases, they even told me that they will not pick the letter, they drew it back to me. That becomes statement, and remember, this could be a witness before the court that demonstrates the efforts that you have put in trying to secure the presence of this person for a disciplinary meeting. Now, assuming all this, should you stop at that point? The answer is no. You will proceed pursuant to a disciplinary procedure to convene a meeting. And this is now a meeting in absentia of this person. And if you are in of course, I expect there are workers representatives either from the union or from the workers committee or from the welfare, as you may call it, have a sitting. And the subject of this will be now termination or disciplinary action against one Peter Kinyanjui. And once the panel is properly constituted, I expect the HR will be there, the supervisor will be there, the workers' representation will be there. Then we are going to have a normal sitting, and this allows us to have another crucial piece of evidence, and these are the minutes. Now, what are we going to be saying in this meeting? It's very simple. As you are aware, this person has not been at work from this date to this date. And we have tried to reach them. These are the call logs which are attached to these minutes. We have tried to do WhatsApp. This is what we have. We have tried to send an employee who is here in this meeting and should be able to tell us that they were not able to secure or to find this person, or they went and this person told them that they are not intending to come back to work. So that is admitted into the minutes, and the parties present do sign those minutes. And once it is signed, now the management now has the discretion to make a decision, which is likely to be dismissal based on that hearing and based that nobody contravened. You see, if the employees would be there, the employees' representatives are there, they could as well ask for more time to try and look, in which case you should allow and minute it. But where you've reached a deadlock or dead end, then in that case, you simply now proceed, do a dismissal letter. Yeah, this dismissal letter should be publicized. Again, that is another key area that I want you to very deliberately take it up. A dismissal letter that has just been signed by the HR and kept in the file is useless in terms of evidence. It becomes a good evidence if there is proof that it was dispatched, that it was publicized. And in this case, where you're not able to get and the employee, the best way is to have it acknowledged. And this is where I've always advised them, the HRs, to use the shop floor representatives who can acknowledge a copy. But the ultimate one would be to have it delivered to the labor office, together with any terminal dues, of course, less anything owed by the company, and also the certificate of service. In the past, you would post it to the address that was declared by the employee, and it becomes even better address where you find that the document is returned and delivered, which becomes another critical piece of evidence that demonstrates that you complied, that you sacked someone. This closes that file to a point that this person cannot later on show up and claim to have been summarily dismissed or orally dismissed. Finally, again, this case which I've said I will share, an interesting point, a very basic, is an employee accused of theft, charged in court of law, secured bond, did not come back to work. Then, as you know, the criminal proceeding aborted at some point. This employee was acquitted and came back to work after, I think, around 8 months. And they went to court saying they were unfairly terminated. What was the defense of the employer? The employer was saying that the employee absconded and that it did not, in any event, ever terminated this person because there was no termination letter. Again, a very enticing way to try to explain yourself out. Yeah, but did it carry the day? No. The employer said, or rather the employee, of course, said that he thought he was terminated because the employer stopped his salary. The court agreed with him. And in agreeing with him, the court, this is Justice Wasilwa, said that the act of stopping an employee's salary is a breach of employer's obligation and amounts to termination. So you stopped the salary, but you didn't do anything to lead to that stoppage. You did not terminate an employee so that you sever the contract of employment and therefore stop the salary. You went ahead, stopped the salary, and stopped at that. This employee was compensated for being terminated unfairly. Now I know I've rushed through, and due to the constraint of time, I think that's the best we could do, but then I'll pass it back to Grace to be guided on whether you can take a question or two. Back to you, Grace.
Thank you, Peter. And Peter has shared his contact details on your screen. You can ask, you can reach out to him, and you can also put Peter on retainer services for your legal matters. But at this point in time, Peter, let me ask you, I had told you to include Uganda and Tanzania. Does the law, are there any different ways of handling in the two places?
No, yeah, you did tell me for the sake of our neighbor countries for consumption. I have gone through the acts, and all of them are almost basically similar. All of them also based richly on the International Labour Organization Convention. Unfortunately, none of them has a prescription on what you should do. And therefore, they are most guided by judge-made law. To make this presentation, I did not only rely on Kenyan law, I also relied on the South African jurisdiction, which is comparative jurisdiction, and also Commonwealth jurisdiction, which is well applicable universally. So what you said is the same that you'll have to apply in Rwanda. Remember, this is all about fairness and opportunity to be had. This is a United Nations human rights right. This is the right to be given a fair trial, to be heard. So this will be applicable in Rwanda, this will be applicable in Uganda, in Tanzania, in DRC. We have said, citing South Africa, and I'm very sure in other comparative jurisdictions. So with this checklist, they can be able to come up with an SOP that will still pass the test of time. Thank you.
All right, thank you for that clarity, Kinyanjui. There's I've seen, because in public service, it actually states that if somebody deserts for about 7 days, they need to the salary no, is it? Yeah, about 7 days, and you do whatever possible to look for them, and they're not, you can stop their salary. Does it
now,
still?
Yeah, the question of stopping the salary is what has costed in the case that I've shared last there.
Yeah.
what is the status? At all times, once you have stopped the salary, what is the status? Are you waiting for the court to finish its criminal process and the employee comes back? Are they on suspension? What is the status? Because the judge is saying that the Employment Act does not envisage a situation where someone is still an employee but without being paid a salary. And this is why the judge has said that the act of stopping the salary in itself is a termination of a key term of that contract. And therefore, you must do that pursuant to a proper law. To a proper procedure.
Okay. And there are two questions here which are similar. An employee absents himself for 1 month before the end of his renewable contract. Do you terminate or wait for the contract to lapse and it naturally ends? Or what is the best practice?
Sorry, I didn't get that. If an employee
absents themselves 1 month before the end of the contract, do you still go through the process or you wait for the contract to naturally end? What is best?
What makes sense is just let that contract lapse, because then that will save you a lot of the procedures. What the best way, just let the contract run.
Okay. There are quite a number of questions on the chat. Some of them I think you've answered in the presentation. Okay, please type your questions on a Q&A. There are so many on the chat, we might miss out on yours because then the Q&A is actually, or rather the chat is really moving quite fast. But Peter, okay, this is interesting. What if an employer, you fail to get in touch with this employee through their contacts and even through the radio adverts? I think you've answered that on what happens there. Yes, we will share the recording. This Lynette was saying, are there any grounds of suspending an employee without pay?
No, I would say, okay, if it is based on your policy, and you remember issues of suspension are actually not provided for by the Employment Act, maybe under Specialized Act, maybe for the public service, or through your policy. Now, you are suspending to investigate, and therefore the outcome of the investigation should dictate whether someone should have been paid. And this is why, in most cases, the suspension policy would provide that maybe you'll be on half salary. If you're found culpable, then you get dismissed. Then if you're exonerated through the investigation, then you get paid for what was withheld in terms of the half salary. But where you're saying you are on suspension with no pay for indefinite period, that's against the law.
Okay. There's somebody who's saying, we have an employee who has been absent from work for 1 month without following proper procedures for requesting leave or permission. Despite being reminded to follow the correct channels for permission, the employee has been asking colleagues to help submit her request instead and has been seen engaging in personal activities. What would be the appropriate way to address this situation? The employee was on a 1-year contract which ends in 2 months.
Yeah, once again, I think part of what you have to make is a very conscious decision where you are given an opportunity maybe to have a contract lapse without the need to go the disciplinary way, which is subject to contesting in court. Then I would say you always allow it to lapse. And in this case, especially where you're saying if you terminate in any event, you still find many employers having to pay notice or in lieu of notice, which denotes that you have actually paid to the end of the contract. So, and when you say they are out there engaging on personal things, there is still that aspect of, is that evidence that they don't intend to come back? So here, somebody is away. If maybe you have got so many months before the lapse of the contract, you can invoke summary dismissal section 44 and dismiss. If you found that
Richard, is it my internet?
Safer.
Oh, okay.
Oh,
Sorry,
we have
I think.
Yeah, that I would add that you just let it lapse.
Okay. What happens when an employee absconds on disability or prolonged sickness?
That person is not absconding.
That
The other.
Okay. What happens if an employee resigns during the disciplinary hearing process? Do you continue with the process or accept the resignation letter? Kinyanjui, are you there?
You can hear me? Sorry, I got disconnected.
There's somebody who is saying, what if an employee has 2 warnings which are active and they desert for 1 month? What is the best way of terminating the contract?
Once again, based on my definition on my definition for desertion, you cannot say they desert for 1 month. Desertion means they don't intend to come back. So here you're asking they're absent for 1 month. Would you allow them to be absent for 1 month? Law allows you, if they do not have justified reason for being absent, even for a day, to invoke Section 44 and summarily dismiss, irrespective of whether they had warnings or not.
Okay. There's an
I don't know whether that is clear.
Yeah.
There's no reason to wait for a month.
Yeah. There's an interesting question here. Why should the employer be held to account, yet the employee has been away intentionally? Why should it look like the employer is begging them to be at work?
I wouldn't say the employer is begging. The employer should actually exercise the prerogatives given to them by law. Terminate. Somebody is not at work and they are not giving reasons. The only obligation here for an employer is to follow procedure. That one, I know we have always said it looks unfair on account of the employer, but then by not doing that, you expose yourself to someone, to paying compensation to someone who is seen working with someone else, and you're still going to compensate them.
Wow. How do you address an issue where an employee deserts work, but because the company is not doing well, they let it be and remove him from the payroll? Later, when it's sorted out and he returns, do you pay the period they were away? Kinyanjui, did you hear?
That is the risk that you don't want to take. Because we have had court cases that actually advises the employer to take action based on the evidence they have at that point. Before you even invoke the police and the criminal jurisdiction, you have reasonable grounds to terminate. If you do, terminate then. Because then the courts have guided that if you loop in that other process, like the criminal process, then there will be an issue of that period that they have been away waiting. What have they been on? But then just looking at the case that I have just shared, I've just told you that the judges interpret the stoppage of salary to mean you have terminated. And in this case, if you didn't follow process, you have terminated unfairly. So waiting is very risky. Go on and make a decision.
And I think there's something that we need to clarify here to everyone, because I've seen this question coming up over and over again. This is what Peter has said. When you have an employee who has been away from work for the period of time that you have stipulated in your policies, and with your all efforts have been put to make sure to try and reach them, and they are not responsive, or they don't show up, you are at liberty to instigate a summary dismissal process. That means you can do a show cause letter, and that is what Peter has said. You need to send them an email, you need to send them a WhatsApp, you need to send them a registered mail so that you can show evidence that you tried to reach out to them. Number two, keep a record of the text messages that you've sent to them or phone calls that you've tried to reach out to them, so that as evidence, and this you need to attach to that file, as evidence that you did everything in your power to actually get this person. Then, if they don't respond, whether they respond to show cause or not, you can go ahead and have a disciplinary hearing in the absentia. And what Peter has also insisted on is you need to make a decision on what to do. Of course, he has also advised that in cases where there is a month to go on their contract, instead of stressing yourself with the other processes, you can just go ahead and not renew that contract, so that then you don't have a lot of issues to deal with in between. I hope that you guys have understood that, because there's a lot of questions going on. They have disappeared for 2 weeks. What do I do? They have disappeared for this number of time. What do I do? I think in summary, what we have been told is, when they have this, you need to have your policies very well clearly stipulated. And then if they're in breach of that policy, you are allowed to do procedure. And what he has advised is you make sure that there is evidence that you've done everything in your power to reach out to these people. And then you have given them an opportunity to be heard. And sometimes I've been in situations where you are sending the second reminder for a hearing, and then this person shows up and they come and they want to start afresh, and you see at some point you had also decided to let them go. So some of these things are, I think, to avoid a lot of repetition in terms of questions, I think those are the facts. So if you have somebody who has deserted or absconded duty for the period of time that is stated in your contract, you need to follow due process to make sure that if you're terminating that employee, it is termination. Now, again, he has also clarified, when somebody is unwell and they don't come to work, that is not desertion. That is somebody on sick leave. And I hope that you have understood that, because I've seen quite a number. Somebody is saying, I'm here for the first time. The webinar is an eye-opener. Do you share a link to same platform? Do you have a WhatsApp group? Yes, we do have a WhatsApp group. Jacinta, please put the WhatsApp group link on the chat so that the people can join and be able to know what's coming up. We'll also be sharing the recording there on the WhatsApp group. Where is this? I'm just trying to look for a unique question, because most of the questions. Okay, where is that? How long should an employee? Okay. Why? What happens when an employee disappears for more than 7 years and the family members appear for benefit claims such as group life and pension? What did you do with the pension? Because pension is not lost unless you paid it out to someone, but they should not lose their pension. How long should we take to prepare final dues for absconding? Is there a specific timeline we should abide by? Kinyanjui? Hiro? Okay. I think his internet has gone. We will get that. The bit of receiving resignation during a disciplinary case, how do you to go about it wasn't answered. We will figure that out now. But normally, if they resign you and give you 1 month notice, you can decide to continue or you can decide to not continue, depending on the magnitude of the problem. Unfortunately, allow me not to get into the sick leave discussions. Today, we are not handling sick leave. We were on a totally different trajectory. Unfortunately, on matters law, sometimes it's easier to get in touch with the legal, and Peter has shared his number so that you can also explain your situation as it is, so that then it's easier to give you to help you how to deal with it. Right. Okay. So the person who is asking about 4 months later, he comes back. What is the procedure when an employee absents himself from work? Then you follow the required procedures, but he doesn't respond. But later, after 4 months, he comes back and claims to be sick with the doctor's report. If you had already fired them and you had already summarily dismissed and reported to the labor office, unless you have a way of determining that it was true they were sick, there either your humanity checks in or because you stuck to your decision. If you already let them go, you already let them go. So you can make a decision on that one. Yes, if somebody has resigned, you go ahead and accept the resignation. We normally say employment is at will. So you can't force somebody to work for you. Yeah. And I think we've lost Peter at this point in time. We will be able to share the recording later. But if you have attended most of our trainings with Peter, he has really answered the question on what happens when an employee resigns during a disciplinary process. Do you accept the resignation and abandon the process? Yes, you can accept the resignation and let things go. In fact, it is an easier way. But if it's a fraud case, then you may need to follow up because that means that there's a criminal cause, whatever case ongoing. So it is handled differently. I don't know whether you have anything to add, Richard.
Wow. I've always thought that I understand the issue of dismissing somebody until Peter has brought certain new concepts, and that is the beauty of attending these particular discussions, because you learn something new, like sending the letter of dismissal to the labor court, like sending certificate of service to the not labor court, I mean the labor department of the government. I have learned quite a number. Don't ever miss these discussions. They are quite revealing. And as always, we always say, it is demystifying some of those complex issues in our careers and businesses. Thank you so much, Grace.
Yes, thank you. My colleague Anne is saying, please unmute me. I cannot find you, Anne. Can you raise your hand so that I can unmute you, please? And yes, I agree with you. That's why I said the humanity side must come in on the case of somebody being admitted in hospital. If their documents, of course, are valid, then that should be looked at. So we have a session coming up in February with Peter, and that will be a paid session. So please sign up for that. I have seen you, Anne. And yes, you can also get in touch with us at Atara Solutions. We are able to give you some solutions to these problems. And there you go. You can speak.
Hi, Grace. Please confirm you can hear me.
But you need to speak louder. I can hear you, but you're very low.
Okay. So I just wanted to make a comment on the issue of when somebody comes back after 4 months. That is a matter that it is not even a humanity issue. It is a matter that has to be looked at completely legally, because this person may have been in the hospital for the last 4 months and probably in the ICU, and they could not have reached the company at the stipulated time. So even if you had dismissed them for desertion and they have come back and they have presented you with documents, it is your duty as the employer to investigate that case and make sure that first the documents are legit and the claims are legit. Because if that matter proceeds to court and they can prove that they were actually incapacitated, you will be required to reinstate them. So it is beyond humanity. But then there is also the people who are trying to play around. And then the issue number 2 is when somebody resigns, when the process is a disciplinary process has been instigated. The internal process does not stop as far as investigations and whatnot is concerned. But assume a scenario where somebody resigns with immediate effect. It means they no longer work for you. So they are under no obligation to attend any disciplinary case, any disciplinary invite that you send to them because they don't know you, you don't know them. So
And you need to be louder.
Oh, okay. Is that loud to you? Oh, okay. So what I'm saying is that the investigations continue as they had been scheduled conclusively, but the resignation stands. So the results of the investigation will probably be filed for future reference, but then you cannot compel them to attend a disciplinary hearing if they have already resigned. But if they have given notice, then the process can continue because they're still working even during notice. But if it is with immediate effect, you continue internally with your investigations and file it, but the resignation is valid. Grace?
Thank you for that clarity, Anne. Peggy, no, we are not done. Why can't you hear? We lost Kinyanjui, but we were just having the discussion and answering quite a number of questions. And Anne has also been chiming in and saying that if somebody resigns with immediate effect, your disciplinary process ends because you can't force them to show up when they have already resigned. However, if you have a fraud case, for example, and it requires investigation and it's also a case of what do we call it? Criminal case, then that continues regardless of where they are. Right. What if they appear back with a fresh list of demands and they continue to work? I don't know where, Miriam, you may need to clarify that on that one. Ati, what if an instance where one is arrested and do you still wait and it is more than 14 days? And you want to answer that?
If somebody has been arrested, there is a clause within the Employment Act that provides that if you are arrested and detained for more than 14 days and you do not show up to work, then your employer has the right to be able to dismiss you summarily, regardless of whether the issue is company related or not. However, we must also, as we read that clause, we must also remember that every person has to be given has a right to a fair hearing. So when I was arrested, and you knew I was arrested, na niko kwa cell, na ukanifuta, did you give me an opportunity for a fair hearing? But then we have to understand there are two issues here. There's the criminal issue that the police is handling, but then there are the internal processes that the company is handling. So how do you find a balance to fit those two in this scenario? Let's say for instance, ameshikwa na amewekwa remand na akatolewa. You will serve them and they will continue with the process. But huyu ameshikwa for terrorism charges, huyo hawezi kuachiliwa, atapelekwa shimo la tewa huko na wewe utamfuta tu without the issue ya fair hearing. I don't think it will suffice at that point. So there is a balance that needs to be looked at that point, Grace.
Thank you for that. And Peter is also back. Peter, we have been discussing the issue of somebody appearing after 8 years and the family disappears for 8 years and the family is back claiming for dues. How do you handle that? And the dues they are claiming for is pension. Kinyanjui, you're on mute.
Hi, Grace, sorry, I got disconnected from but I've been listening in, although not as an admin. Anything for me to respond to?
Yes, I was asking about that person who shows up 8 years later. And the family is coming back to oh wait, there's somebody who comes 4 months later and with a doctor's report, which Anne has answered, but there's this person who comes back after 8 years of desertion and the family is claiming for whatever, for dues.
Yeah, dues they are entitled. That is, if someone had accumulated money, you're supposed to give. Because what the law provides, what the Employment Act provides, is that if somebody, including even in death, that is where you cannot be able to trace who you are supposed to pay the terminal benefits to. You are supposed to pay to the county commissioner. There is an account there, or the Ministry of Labor, who will hold that money until that person comes. So if it is terminal benefits, they are still entitled to get their money. If it is about claim for unfair termination, that expires after 3 years. That is the limitation period. You cannot raise a claim older than three years.
Yeah, because this one comes back after 8 years. Abu is saying, after sharing the termination and final payment documents in the labor office, what should I request for?
What you need to put in your file, not really request, is that if you present these documents to the labor office, you should have them stamped with a date that they have been acknowledged at the labor office. So, and for me, and legally, this now becomes evidence that you carried out the process. And what I've seen situation, or how I contrast that is with a file that there is a dismissal letter, but no evidence it was ever taken out, because the courts will assume that you actually did a letter and backdated because you have been sued. So it is one way of ensuring that you have an acknowledged letter that you now file, and also an acknowledged certificate of service, an acknowledgement of the computation of the terminal benefits, and maybe even a copy of check if you are paid through the check. That preempts someone from coming later on to claim that they were verbally terminated or something like that.
Okay. I think we have answered quite a lot, and I see it's already past 9:30, so we may need to bring this to a close. Please look out for the sessions with Kinyanjui. We've done quite a number of them, and we are also planning one for February. Please sign up. Those ones we normally do for 3 hours, so don't be left out. It will not be as short as this one. Yeah, I'm trying to see whether there's another salient issue there. So question, does this apply to all categories of workers like casuals and contract?
I wouldn't know to start on that. When you said that's this, I don't know whether you're talking about the procedure. Of course, it doesn't apply for a cashier who is deemed to be paid on a daily basis, and therefore that way there is no need for a process to terminate or something. And that person cannot desert, because in any event, their contract is for a day only, 24 hours. But for someone on a long-term or on a term contract or permanent, then yes, the procedure would apply.
All right. I think, I don't know, Iba Malema, what you mean by final dues and all those question marks. You may need to clarify on that. We had a case where 2 officers were arrested bridging curfew times. The officer suspended. We did investigate. David, that story, please put it on the Q&A. Kindly reshare the WhatsApp group. You can share the WhatsApp group, Jacinta, as well. Okay. I think we've covered quite a number of them. Can the February training be planned? Let me see that. My laptop today is misbehaving. And can you read that? Can the Tuesday, whatever, be planned?
From which section, please?
On the chat, there's somebody who's commenting about this Tuesday, the February session being planned.
Okay, to locate that.
Okay. Anyway, I think
the February training planned be done regionally, That is the question Christine Chikuku is asking.
Regionally, in terms of the entire East Africa, or regionally meaning what? Maybe you can also say that, or we can come to your towns as well.
Yes.
All right. I think the February session, we normally have a virtual call. That one, which is normally about 3 hours. So we are planning one for February on different topics. I think the last one we had was 2 months ago, which was on termination and what did we do? Contracts. So next year we are also planning to have a couple, maybe 4 of them. And if you want physical sessions, you can tell us. If you're signing up your people, we can also do physical sessions as well, so that we can also help you become better professionals in your areas of work. So thank you very much for being here tonight. I think we can call it a night at this point. Please do not forget to come for the dinner on Friday next week. I hope you've seen our flyers. Please look for that Touch of African. Come, let's learn, let's share, let's interact. Let us network, let us come and learn how to grow our careers as we go forth. We are preparing for 2025, and it's got to be the year for you. You know, 2025 has to be your year. So we will share the recording as well as soon as it's ready. And please see you next week on Tuesday. We will be looking at investments and your money market funds. And then we shall see you physically on Friday at Westwood Hotel in Westlands on Elder Maravin Road. So that then, and if you're coming for the dinner, please take the Kabete route, not the Westlands Mall route. That one you'll be far. So at this point in time, thank you very much. I'll see you on Tuesday as we tackle another topic. But see you on Friday physically. Peggy Ngaira, I hope you have gotten your Touch of African. We look forward. Share more on contract and term employment in February. We will have the flyer done. And then we will share as well, and you can sign up for that. That is normally a paid up session, so you have some savings and you can pay for it, and you can talk to your employers. They can also pay for you, and come and join us. It's normally 3 hours of engagement, and we'd like to choose a topic that we can actually discuss exhaustively, so that then as you go back, we are not leaving any question unanswered. So please join us at that point in time. So thank you very much for joining us tonight. We really appreciate you. Peter Kinyanjui, your parting shot?
Yeah, as always, it's good to have been able to be part of this discussion. We look forward to the next one. We know we are constrained in terms of time, so we hope next time to even go more practical and even be able to share standard operating procedure for this kind of separation. Just make sure that you're able to close any gaps. Otherwise, thank you very much. Have a good evening.
Thank you so much, Kinyanjui. We really appreciate you and your input. As always, it's a pleasure. To you, our audience, thank you very much. Richard and Catherine, always a pleasure. I don't know that, Richard, you had your closing remarks as well.
Thank you so much for this particular discussion. Always remember documentation, 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 documentation. That is what courts do. Madam Nagani, Peter.
Yeah, you nailed it.
Okay.
Absolutely, absolutely. So yes, thank you. And somebody is asking, does the 4,500 cover dinner? Yes, it does. 4,500 is actually inclusive. You just pay a one of 4,500 for the dinner next week. It includes everything, learning, registration, everything that you will get to experience there is inclusive in the 4,500. So please pay up and see you physically on Friday next week. But please do not forget to sign up for Tuesday as well here virtually as we discuss money markets. So thank you, Richard. Thank you, Catherine. Thank you to you, our audience. Thank you to our speaker. Thank you, the team at Tara Solutions. Thank you for your input. Thank you very much. And we look forward to more conversations and as we continue to grow. And we appreciate your comments as well, and thank you for the support. As we close the year, we are closing the year strong. I think our session will be on 20-something of this month, and then we can take a break in December and enjoy some corporate dinners that are happening. In the meantime, asanteni sana. Have yourselves a lovely night. Do not forget to sign up for the dinner. George Etiang, please don't forget, from Uganda. Do not forget to join us in Rwanda on the 20th. But there's also the annual conference happening for HR Mau. I have seen my good friend, what's his name? Andrew is planning for the annual conference for HR Mau. Please attend that one as well. Let's keep learning, let's keep sharing knowledge, and let's keep these conversations going. So asanteni sana and have yourselves a lovely, lovely evening. Good night.